General, one section of the provision at issue here applies when a court order includes a finding that the person represents a credible threat to the physical safety of such intimate partner or child. But another provision applies when the order, by its terms, explicitly prohibits the use, attempted use, or threatened use of physical force. That does not require a finding of dangerousness. Why is that necessary, and how can that be justified?
I think ultimately a court would have to find dangerousness to enter a subparagraph C2 injunction based on the general equitable principle that in order to enjoin conduct, you have to think that conduct is reasonably likely to occur. This is a universal equitable principle. It certainly applies in Texas and in virtually all of the states. And I think what it means is that a judge who's considering a request for a protective order wouldn't have a basis in law to enter that subparagraph C2 prohibition on the use of physical force unless the judge thought the force was sufficiently likely to materialize.
Well, we are told in some of the amicus briefs that there are situations in which the family court judge who has to act quickly and may not have any investigative resources faces a he said, she said situation, and the judge just says, well, I'm going to issue an order like this against both of the parties. Do you agree that that occurs?
No, I think that that is largely a mischaracterization of what is happening in the state courts day in and day out. With respect to mutual protective orders in particular, the vast majority of states, we cite a source that counts 48 of them, either prohibit outright or substantially restrict the entry of those kinds of mutual protective orders. And then I think the account is basically trying to suggest or insinuate that these state courts are nevertheless entering protective orders that are not justified by the facts and the law, and that just flies in the face of the presumption of regularity that this court applies in this context. Even the data on the ground don't bear out the assertions that family courts are just reflexively entering these kinds of protective orders. By respondents' own count, in the particular Tarrant County statistics he collected, there were 522 requests for protective orders, but that only resulted in 289 final protective orders. So I think even as a statistical matter, it's incorrect to say that invariably these orders are being entered without any basis in fact or law to justify them.
Is there anything that a person who is subject to one of these orders can do if the person claims that there wasn't really sufficient notice, or that due process rights were violated in some way, or that any need for the protective order has expired? Presumably the person could go back to the state court that entered the order, but if the state court is completely unreceptive to that, is there any other avenue for relief?
So I think it's important to parse out different aspects of the question. Certainly in a Section 922G8 prosecution, an individual could challenge the adequacy of the notice or the hearing. And so if the argument is I didn't actually receive the notice or I didn't have an opportunity to participate, that would be a defense because Section 922G8 requires that.
Yes, but before the fact, so the person thinks that he or she is in danger and wants to have a firearm, is the person's only recourse to possess the firearm and take their chances if they get prosecuted?
No, I mean, I think the person would obviously have an ability to, within the state court system, challenge the entry of the protective order. But I don't think there would be any basis to say you could collaterally challenge that in the federal prosecution. And ultimately, this just reflects the history and tradition demonstrating that there are certain categories of people where we don't have to tolerate the risks of armed domestic violence that they would present, even in situations where they might claim that they need to have a gun for other reasons.
There's no recourse before the fact in federal court?
So I think that they could seek recourse in the state courts themselves. They could protest the notice and the opportunity for a hearing. But if a court has entered a protective order that complies with the restrictions in 922G8, then a federal court can rely on that in enforcing this prohibition.
Is there any possibility of administrative relief?
I think that at the state level, there are certain mechanisms in place where people can seek relief. And one important thing to emphasize is that these protective orders are inherently time limited. It varies a little bit at the state level. I've seen provisions that authorize the imposition of these protective orders for 6 months up to about 5 years. I think most commonly they're in effect for just 1 year. But, you know, and the federal firearms prohibition tracks the length and duration of the protective order. So that also, I think, means that the disarmament lasts only so long as the danger is in effect.
Well, one more question. The Alameda County Public Defender's amicus brief says that some restraining orders are permanent. Is that true? And if that is true, how do you justify a permanent prohibition, even if any danger has disappeared?
So I'm not aware of state law authority that authorizes or that routinely enters permanent protective orders. As I mentioned, this varies across state law, so I don't want to suggest that there's a universal answer here, but these orders are generally time limited or provide mechanisms for courts to go back and review the finding of dangerousness for purposes of effectuating the basic command of the protective order.
Thank you.